to Antonin Scalia Law School professor Adam White on what that new justice could be facing coming in. It would be a busy docket, wouldn't it?
Well, it will be, Neil. The court's already agreed to start taking cases, including a closely watched case about double jeopardy, which could implicate questions about pardons. I do think that the court could manage its docket with an 8-justice court for the time being. I thought the same during the Garland nomination. But I just think that it would be good to get the president's nominee on the court for the sake of having another good judge on the court.
You know, Adam, history is such that usually you get one surefire pick out of a president for Supreme Court justice is remarkable. To get 2 back-to-back would be historic. It normally doesn't come that way. Ronald Reagan and George Bush Sr. found out the hard way. It doesn't always pan out the way you hope. So this would be a president kind of defying history if he has back-to-back winner choices, right?
Well, that's true. The two seeming frontrunners, Judge Kavanaugh and Judge Hardiman, they're both conservative. They come from different places, both biographically and also the courts. Judge Hardiman has been on the Third Circuit, Judge Kavanaugh on the D.C. Circuit. If you're looking for back-to-back solid picks, then Kavanaugh is probably the safer choice, if only because he has a longer record on the D.C. Circuit of hearing constitutional and high-profile regulatory cases. He's more of a known quantity. In fact, his record sets him forth as probably the leading intellectual leader of his generation of judges. His record of opinions on structural constitutional questions and high-profile regulatory cases is very solid.
He's a remarkable mind. I mean, but with that ample 14-year-plus written record of opinions and dissents comes some baggage that you get with the time. And again, in the eye of the beholder here, but he had worked with the White House counsel at the time, Alberto Gonzales, who later went on to become Attorney General, helping check judicial nominees for their commitment to a conservative legal agenda, his ties to George W. Bush, then the independent counsel in Ken Starr's investigation of Bill Clinton. That the more experience you have, and he has ample, impressive experience, and I've read some of his opinions, they're remarkably and so lucidly written and clearly expressed. It could also work against him, right?
Well, that's true. Having a paper trail means having more targets for your critics.
Right.
But at the same time, if the goal is to pick the best possible judge, and I don't mean any slight to Judge Hardiman, he's very impressive in his own way, Judge Kavanaugh's long paper trail should be a plus, not a minus. If something's worth doing, it's worth doing right. And if this requires a little more time and effort by Senate staff and senators and folks in the Justice Department to produce the record and to go through it, well, that's work worth doing.
You know, you could clear this up for me. There are a lot of people who have called him, I know this term, I've gotten to learn it from very smart lawyers like yourself, that he's more of a proceduralist, that is Kavanaugh, that his opposition to key healthcare law issues had to do on procedural matters rather than broader legal arguments. I don't know how true that is, but he's such a technician, such a fine-tuned technician, that he will argue on those grounds. And then some conservatives had claimed that that showed a lack of fire for conservative causes. What do you make of that?
Well, I don't know if I would call him a proceduralist. You're right that of all of his opinions, the one that has brought the most criticism from conservatives was his opinion in one of the individual mandate challenges.
Exactly.
Where he said that the case wasn't really ripe for the court because of its procedure in the tax context.
And he was technically right about that. He was technically right at the time.
It was a reasonable conclusion.
Right.
I will say in his broader body of cases on the separation of powers, on agency structure, on the deference that courts give to agencies, he's been very good on these substantive questions. And so I don't know that I would call him a proceduralist. I'd call him a separation of powers guy.
All right. I'll stick with proceduralist because I understand that one. But no, I'm only kidding. Adam, thank you very, very much. Adam White.